Today, I'm going to briefly introduce moral rights and especially the international antecedents, which under international law, under the Berne Convention, uh, provide for several mandatory rights. In particular, the right to claim authorship, known in sexist language as the right of paternity, and second, the right of integrity. Uh, to object to any distortion, mutilation, or other modification that would be prejudicial to the author's honor or reputation. Berne specifies that protection should last at least until the expiration of the author's economic rights, but countries may opt to cease protection of moral rights after the author dies. Many countries also recognize a moral right of divulgation or disclosure, which allows an author to control the terms under which their work may first be disclosed to the public, similar to, but not precisely, the US right of first publication. And there's also a moral right that distinguishes it from the right of first publication. The right of divulgation also covers withdrawing the work from circulation if it no longer represents the author's views, which obviously goes beyond first publication. There are some other principles of US law that protect aspects of these rights. So the ability to control reproduction and distribution through contract, the right to terminate a transfer, but we didn't enact a general right to disclaim or claim authorship, and we didn't enact a general integrity right. The Berne Convention Implementation Act stated that existing US law was sufficient to satisfy the United States moral rights obligations. TRIPS, which actually has enforcement provisions, unlike the Berne Convention, specifically excludes moral rights at the US's insistence, because in fact, we don't like them and see them as barriers to trade. So here's the best argument for why we are nonetheless in compliance with Berne that I've heard. If you look at the rights conferred by Berne as a US textualist, it sure looks like we don't comply. But no other country is as textualist as US lawyers think. Nobody else interprets these rights very rigidly, even if they appear to provide them more broadly than we do. There are often reasonableness limits on the exercise of moral rights in other countries that make the US system not all that different, despite our significant policy disagreements on things like fair use. That being said, we really clearly do not have a general right to claim authorship or general right to object to distortion. So most other countries don't necessarily think that the contractual control that you get in terms of being able to claim authorship and authorize specific derivative works, most other countries don't think that that suffices. But the gap between them and moral rights may not be as big as a US legal education would lead you to believe. Now, other scholars think that the results in the Daystar case changed our compliance with Berne. At the time, Congress listed 43A of the Lanham Act as one of the protections against distortion available to authors. That's much less plausible now. In the Daystar case, Fox sued for, among other things, a violation of Section 43A because Daystar allegedly claimed the work as its own without revealing the source of the material. So there's a claiming authorship aspect of this. And in previous 43A cases, there had also been some distortion protection victories for author claimants. Fox, by the way, also sued and later won in the Daystar case based on a claim that the recut documentary infringed the book on which the original documentary was based, and the copyright in the book had been renewed. So under the principles we've already learned, it actually was infringing anyway. But there's no Lanham Act claim. The Supreme Court holds that false designation of origin is limited only to the manufacturer or producer of physical goods, and that's Daystar. Consumers might care about the origin of creative products, but interpreting 43A to cover that situation would create a conflict with copyright law, which it itself allows the right to copy and the right to copy without attribution once copyright has expired. When Congress wants to create an exception to that general rule, it knows how to do so. If Fox's argument had prevailed, by contrast, the Visual Artists' Rights Act type protections would be available to all authors, and VERA's stringent limits would be superfluous. In addition, the Daystar Court reasoned, the word origin has no discernible limits when applied to communicative works. In Daystar itself, some of the film footage in the documentary came from the US government, other parts from other sources. Fox was not the origin of those components. In fact, Fox was not the origin of anything. It had simply licensed the right to distribute the series from Time. So the last thing I want to do is introduce a case that's mentioned in the 5 Points case because it is of local interest and also illustrates some of the complexities that come up in VERA cases. So the Massachusetts Museum of Contemporary Art Foundation litigated against an artist named Buchel in the First Circuit. There was a failed relationship over an installation called Training Ground for Democracy. Buchel's not a traditional painter or sculptor. He assembles objects. There's some suggestion that Buchel might have purposely forced the exhibit to grind to a halt as the final act of the work itself. So he's an artistic provocateur. In 2002, for example, he sold his invitation to participate in an international art exhibition in Frankfurt for $15,000 in an eBay auction to allow the winner to take his place. He also sold signed copies of the museum's complaint and his own correspondence in this case, Mass Mocha versus Buchel. So the image that I hope to show in a moment is a mobile home that's being moved in for the installation that at issue in the litigation. Buchel reached out to the citizens of the neighborhood, inviting them to donate whatever junk was cluttering their basements and attics. They responded by carting it to the museum by the truckload. The annual operating budget for the entire museum was only $800,000, and they spent nearly half of that in what turned out to be the initial stages of this one exhibition. Buchel made increasing demands for the museum to bring more and more objects in, including an actual aircraft and other items from Iraq. Ultimately, they stopped. And in an attempt to get something out of the disaster, began offering people the ability to see the partial exhibit and then the ability to see the exhibit with cloth thrown over it. This was what resulted in the VERA dispute. One critic who visited the cloaked exhibition said, "The monumental elements of the installation rise all around you, plain as day. The cinder block walls, the two-story house, the guard tower, the trailers, the carnival ride, all compacted together in a claustrophobic, politically surreal borough of hell. George Orwell by way of David Lynch. Even cloaked and abandoned, the dense physicality of the materials energized the vast space and wielded a startling, oppressive power." On the other hand, the New York Times critic wrote, "The shrouded non-Buchel is a kind of museological car crash. You can't stop looking, but tarps or no tarps, you also want to avert your eyes, especially if you're familiar with his previous work. It will certainly give people unfamiliar with his obsessive, history-driven aesthetic an inaccurate sense of his art, and this is indeed a form of damage." Ultimately, the museum decided to dismantle the work. Buchel later created a tiny version called Training Ground for Democracy at a German museum. And in the actual case, which we can talk more about in class, the court made several holdings of legal note. First, unfinished works are protected by VERA to the extent that they're fixed at any given point in time. So Buchel did in fact qualify under VERA to bring a claim. Second, the plaintiff has to show some prejudice to honor or reputation, no matter what remedy is being sought, which was an open question. So injunctive relief or money damages, you have to show damage to honor or reputation. Integrity violations can lead to money damages, but attribution violations, the court held, can only be protected through injunctive relief. And we'll discuss the various theories of harm in this case in class and whether those remedy limits reflect the underlying theory of harm. So I will see you.